welcome everyone to another episode of Circle City Conversations. My name is Alex Limontes. I want to thank everyone for their continued support. I want to thank our primary sponsor, Hurst Limontes, an Indiana law firm with over 50 years of experience helping injured Hoosiers and their families. I am here today with attorney Chase Wilson from my office. This episode is a very special episode because it is part of our litigation lessons series where we talk about recent cases that we've litigated and or tried here and across the state of Indiana. The last litigation lessons episode was attorney Catherine Karras from my office, who tried a trip and fall case against a landlord up in Fulton County, Indiana, and she was successful in that case. And Chase is over there yawning. So
I don't know what you're talking about. It's been a long day.
This episode, we will focus on a jury trial verdict that Chase Wilson and I recently obtained in Marion County Superior Court 3 in front of the Honorable Judge Gary Miller, who was a pleasure to work with.
He was.
And should definitely be a guest on this show. Hint, hint, if he's listening. If anyone is listening. So, Chase, thank you very much for being here. I really appreciate it.
Of course.
So, Chase, funny enough, our client's name was also Chase.
Yeah, that was a little weird for me.
Yeah. So, it's not like a common name either. You know? It's not.
If our client's name was Alex, it would seem normal, right?
Right. Yeah. But yeah, you don't hear that name very often. So tell me a little bit about the case. Briefly summarize it, and what kind of case it was.
Yeah, so it was a 3-car accident, rear end accident on 65 North. Our client was the front car, and then another vehicle behind him got rear-ended by the defendant, and that middle car got pushed into his.
Okay.
So a little bit wonky on how the accident actually occurred, and then the damage to his vehicle was actually fairly minimal to the blind eye. He had a bent rear bumper.
Yeah.
But it doesn't look like a crushed in rear end, which is one of the problems that came up. And then he had some treatment for neck and back pain. He did a little bit of physical therapy, but not very much. They had told him to go get injections, and he didn't want to do that. I think he ended up having one. They recommended several. And then he had some pretty large gaps in treatment where he was a big, tough guy. You got to meet him. Yeah. He's your size, except my age. Yeah. And he looks like Thor. He's like 6'4", and just jacked, with the long hair and a beard. So the issues in the case, though, that came up were the fact that there wasn't a ton of property damage. This is a young kid who it doesn't look like he should be hurt at all.
Right.
And he had some gaps in treatment that ultimately that's why we had to try the case, and we had an offer beforehand that we just couldn't accept.
Yeah. So, and you're right. I remember the first time I saw him, I was like, this guy looks like a WWE superstar guy, someone you would see flying off the top ropes, do like a suplex or something. So we had, I would say, and I was really second chair in that case. I did jury selection, and then I did the second closing, and you did basically everything in between. So I told the jury that I was the bookends. So I got to an opportunity to watch you kind of put the case out there and put it forward. And when I talked to other people about the case, if you handle a lot of these cases, car crash cases, we see a lot of the same things over and over again, a lot of the same defenses. And it was the case that had every one of those in it.
Yeah, it definitely wasn't an easy one to try.
Right. Yeah. I mean, gaps in treatment alone are hard enough to overcome, right?
Yeah. And then I forgot to say, and then he got in the accident and treated for like 6 months. Mm-hmm. And then by the time we got to jury trial, it had been another 3 years. Right. And he hadn't had any treatment in that time. So, right. And we're trying to argue to the jury that he has permanent ongoing pain, and defense counsel, of course, is going to argue, well, then why isn't he going back to the doctor?
Exactly.
So, we really did have just about every issue that you see that comes up in a car accident case.
Absolutely. And one of the things I remember defense counsel said this, he said, this is the textbook definition of a fender bender. And that was smart. On his part. Not necessarily true.
Yeah.
But a smart argument to make.
Yeah. No, especially if you don't know what a fender is.
Right.
It's not a bumper, but what are you going to do?
Educate our audience. What is a fender?
So the fender is the right rear or the left rear or the right front or the left front corner of your
quarter
vehicle.
Panel.
Yeah, it's like the quarter panel. A bumper is not a fender.
Right.
Otherwise, it'd be called a fender.
Right. And our client, what kind of vehicle was he in?
He was in an old, 1990s, S10. It wasn't an S10. I can't remember exactly what it was.
GMC Sonoma.
Yeah, that's right. But it looks like an S10, and they're built with a solid steel frame. They don't move when you hit them.
Right.
So to move, his rear bumper was bent into a U shape.
Yeah.
That's a single piece solid steel bumper.
Yeah.
It was smart on defense side to classify that as a fender bender to a jury who maybe doesn't know that's not how hard that piece is to bend. But it's just not what it was.
And another perfect example of how the pictures can be very deceiving compared to what the actual damage was, right?
Yeah, and I think we did a good job of using that to the best of our ability.
What are some of the things that you did in our case in chief to try to deal with this? I'm never going to say low impact because I hate that term. I'm always going to say not a lot of visible property damage. So what were some of the things you did to deal with that?
Well, we used it to deal with that issue, but also other issues throughout the case, right? You and I talked a lot, and it was the first time you and I had a chance to try a case together. So that was interesting because we think very differently about most things.
Right.
But it was kind of throughout the case, the theme was there's more than meets the eye.
Right.
So we showed pictures of the first vehicle where it didn't look like she had a ton of damage if you were zoomed out. But then when you zoomed in, you could see that her radiator was cracked and there was whatever that fluid is leaking all over the place. And that radiator doesn't just break unless there's a pretty heavy impact. And then we used the second vehicle and put up a photo of the second vehicle with the bumper cover still on.
Yeah.
Which again didn't look horrible, but then you take that plastic piece off and you realize that the steel beam in that second car had snapped in half.
Oh, wow, yeah.
And then you look at just the photo of Chase's truck, and that bumper is bent, which if you don't know anything about that kind of car, maybe doesn't look that bad.
Right.
But then we also showed a video or a photo of his truck bed had actually separated from the cab.
Yeah.
Which doesn't happen unless there's frame damage. So it was a whole series, even on the property damage portion of there's more than meets the eye here.
Right.
Just because it doesn't look bad at first glance doesn't mean it isn't. And in this case, it was much worse than it looked, to a blind eye.
Right. And it was a chain reaction car crash.
It was, yeah.
Which means there was at least enough forces involved to push one car into another one. Right?
Yeah, and I wish there weren't limitations to what we can do in these cases, right? Because some cases don't justify going out and hiring somebody to do a complete reconstruction and tell you about how these forces transfer between vehicles.
Right.
And that last car is actually going to feel the same force as the second car.
Right.
But when we talked to the jury afterwards, that was, that got brought up to us.
Exactly.
That he was the last car, so, yeah.
And I mean, that's a circumstance that we run across. We were just talking about it in your office. Is the value of the case enough to justify paying some expert thousands of dollars per hour to provide an opinion, on an issue that may or may not, get you that money that you're looking for then?
Yeah, and I think that's something that comes up a lot in what we do. And I know that we handle it differently than other firms.
Yeah.
I know there are other firms that maybe would have just spent that money with no consideration for what that does to the client in the end. But we're always conscious of, okay, if we spend this money, how sure are we that it's going to pay off?
Yeah.
And if we're not sure that it's going to pay off and put more money in the client's pocket, then we don't necessarily want to incur that expense on behalf of them. And then they get a verdict and you go, sorry, there's no money. We spent it all.
Right.
Because that's not fair to them.
Right. I mean, at the end of the day, then you've got a verdict, which is good for the lawyers and great for our ego, right?
Yeah.
You know, we won a case, but ultimately it's about the client and making sure that we can maximize what they get in their pocket. Yeah. And if you're out hiring experts willy-nilly that you don't really need, you're taking away from the client. Yeah. So this was a soft tissue type case. There was no broken bones or anything, right?
Right.
And we also had another hurdle on the other side, significant one in my opinion, in the fact that it was what we call a substandard insurance company.
Yeah, those are always good to deal with.
Let's talk a little bit about those companies.
So most of them at this point, I think that we deal with fall under one umbrella, that Fred Boya umbrella. Yeah. It's an insurance company out of Texas that's bought up a bunch of different companies like First Chicago and American Access and all these places. And they just aren't ever really going to put a full value on a case. If you're going to settle that case, you're going to settle it for less than it's worth.
Yep.
Or you're going to settle it on the doorstep for close to what it's worth. Or you're going to have to go try the case.
Yeah.
But the cases are normally small enough that attorneys don't want to go try it.
Right.
And this case was maybe one of those cases too. The difference is we were willing to go take it to trial.
Exactly.
And I wish more people would be willing to do that on these $25,000 policies.
Right.
Because it would make these insurance companies stop treating claims that way.
Exactly. And not just that, Chase. You were hell-bent on trying it in one day.
Oh, yeah.
You wanted to get it done in one day, and a lot of that is the cost, too.
Correct.
For the client.
Mm-hmm.
We were able to try the case for, I think, a little less than $5,000.
Yeah, we kept costs pretty low.
Yeah, and we did have a doctor testifying.
We did.
So we were able to save money, on those costs. And ultimately, we got a good result for the client. And because we didn't spend money where we didn't need to spend money, all of that went back to the client.
Yeah. Well, and then, something else we've always done is on the back end, he had outstanding medical bills that we were able to call and get reduced.
Correct.
And liens we were able to get reduced. So that we were able to put more money in his pocket.
Yeah. Including a $5,000 MedPay lien that you got completely waived, right?
Yeah. And that's something we do all the time.
Yeah. And if you think about that, so for anyone listening, your own insurance policy usually has medical payments coverage on it, and then they pay for your medical bills. And so that was $5,000 in medical treatment that was paid for our client that we did not have to reimburse after the fact. We saved the client all that money. And so ultimately it's to the client's advantage.
Right. That's $5,000 more in his pocket at the end of the day.
Yeah. So this case, we had a really shitty offer, didn't we?
Yeah. The final offer before trial was $6,000. And our client's medical bills were $7,500.
Yeah.
It made no sense. You said something earlier about spending money for a trial that doesn't make sense. And it makes us money if we get a good verdict, and it strokes our ego, right. But it doesn't help the client. And it's very simple. In this case, if he had accepted that offer, we would have gotten paid.
Right. And
our expenses would have been reimbursed. And his medical bills maybe would have gotten paid if we could negotiate them down far enough, but he would have had nothing.
Right.
So it's just a different mindset, I think, here than it is other places.
Yeah. And ultimately, when it comes to kind of determining that, the other issue to consider is the fact that the amount of time that it takes for us to get ready for trial. So you said it, that let's say the $6,000 offer, our fee on that would have been a third, $2,000. Sure, we would have gotten paid a couple $1,000s and done, dozens and dozens of hours less work on the case. And that's why you find a lot of law firms that will settle these soft tissue injury cases for less, because for them, they run so much volume at their firm. They do so many of these cases that it makes more business sense, financial sense for them to put less attorney hours into the case, and then settle it instead of trying the case, right?
Right. And I think that's a big difference between a firm like ours and one of these big firms, right? Our focus has never been how do we make ourselves the most money we can.
Right.
I turn away cases all the time when people call in and say, hey, I went to the ER once.
Yeah.
Can you guys help me? And it's like, well, are you going to go back? No.
Yeah.
Okay, well, I can sign your case and maybe they'll offer you 5 now and I can get you 7,500. But the only person making money in that scenario is me because that extra $2,500 is my fee.
Exactly.
So I'm not making the potential client at that point any more money.
Yeah.
It doesn't make sense for me to take that case.
Mm-hmm.
Right?
Exactly.
And I tell them all the time, I'm not in the habit of only making me money.
Right.
If I can't make the client or potential new client money, it doesn't make sense for them to have a lawyer.
And under that circumstance you just mentioned, and that happens all the time. We get these calls. They're like, I went to the ER, we tell them, well, you can try to get that resolved on your own. You should be able to. And if we did get involved, we would only prolong that process, and to no financial benefit to the client.
Right.
Yeah. So let's dig deeper a little bit into the case. So I mentioned, I'll talk a little bit about jury selection. I did jury selection. Some of the things that in hindsight, I wish I would have done. Number one thing was ask for more time. We as lawyers tend to be long-winded. We do. And I'm very guilty of that. And part of what I like to do during jury selection is to kind of educate the jury on bias, because I think that's important for them to understand it. Because, you can say the word bias to anyone, they'll be like, okay, well, yeah, I'm not biased because I'm just not a biased person. But to educate them on kind of this hidden, implicit, subconscious bias that everyone carries with them, and get them to understand, that's the difficult part. And so I definitely wish I would have asked for more time, and I ran out of time. I think but I don't know how much more time I would have gotten.
Well, and that's what I was going to say is most judges in these cases, specifically in a case where we told him beforehand, we want to try this in a day.
Yeah.
And we think we can. And defense counsel's not going to present any witnesses.
Right.
I don't know that Judge Miller is going to give us more time, and I don't know that anybody else is either.
Right.
I think we had like 30
minutes.
30 minutes each side. But jury selection is really hard because of that. You have a very limited amount of time to get to know 14 people well enough to decide whether
that's all you get in the box.
Yeah.
And that's just the box. You've got another maybe 10, 12 in the gallery, right?
And trying to figure out who those people are kind of at their core and how they're going to handle what you're about to present is almost impossible in 30 minutes.
Yeah. Remember that one lady said, are you real people? What did she say? Are you actors?
She asked if the gallery were actors, and I believe at that point we said
she was I think she was pointing to you and maybe. Chase. Yeah. Like are those real people? Like
I must have looked really good.
Are you actors?
But I remember we asked afterwards if she could be struck for cause because the statement was just so delusional. Yeah. And the judge, he was like, "No, I mean, you'd have to get more than that."
Right.
Which makes sense.
Right.
That's a pretty high standard to strike for cause. But
right.
It was weird.
Yeah. Yeah. So again, I wish I would have asked for more time. And then also, here's the other thing in hindsight: because time was limited, I should have condensed everything that I was doing. I mean, really just into tidbits of information that I could get from folks.
I mean, you and I have talked about this. Every trial, if you're trying a case correctly, and if you care about the outcome, you're going to learn something with every single case you try. And I have every time. Yeah. And in this one, it was somehow we've got to, at least in jury selection, somehow we've got to figure out how to speed that up, even though it's really hard to do that sometimes.
Yeah. During jury selection, I should have spent a lot less time trying to educate the jury on bias and then hitting the main problems with the case. Because, we all kind of believe around here when it comes to jury selection, all that bad stuff, bring it out. If you think that lawyers like us charge people too much money, if you think that there's too many lawsuits in the country, if you don't believe in giving people pain and suffering, if you could never find a doctor, negligent, all of those bad things, let's talk about them, bring them out, because that's the way for us to get the best jury. Because, it's like I told them when I was talking to them, if this was a child molest case, for example, I would not be a good juror. And I would say that to them. I cannot be really we would. Yeah. And we both have small children, and I would not be a good juror. But if it was, a real estate dispute or something, or even a PI case, I would be a great juror for it, because I can look at that objectively. Maybe not a PI. They would never pick us for a PI case.
And we talked about how many issues were in this case before, too.
There's
minimum impact. There are gaps in treatment. There's no ongoing treatment despite us claiming a permanent injury. When you have that many issues in a case, it makes it even harder to talk to the jury about that in 30 minutes.
Right.
You can't.
Right. And the doctor was, I will say, shaky.
Yeah, so it was the first trial she'd ever testified in.
Yeah.
And you could tell.
Yeah, it was by video too.
Yeah,
so
she was very nice. She was very plaintiff friendly. Mm-hmm. She wanted to help her patient. But she's also very timid.
Yeah,
and you find that a lot with practicing physicians. They're not us.
Right.
They didn't sign up to go talk in front of people all day.
Right.
And sometimes they're just not very good at it. But that's what she did well. She was just she's very shy.
Yeah. So let's talk a little bit about some of the other stages. The opening statement, you did that.
Yeah.
How was that?
It was great. I felt good about it, other than the fact that the podium was in the weirdest spot ever.
Yeah.
And if anybody listening, if you've never tried a case in the new CJC, you don't find out what courtroom you're in until maybe the night before at 8:30 at night, or that morning when you walk in, and they're all set up slightly differently.
We couldn't move the podium too. Remember that? They wouldn't let us.
You can't move the podium.
Yeah.
And it's in different positions in every courtroom. Katie and I tried a case a year and a half ago where it was in the middle of the floor, where it seems like it should be.
Yeah, where you can face the jury and face the witnesses and face everyone.
Yeah, so during opening statements, I only had 4 slides because I don't want to depend on a slideshow in my opening statement.
Right.
I want to talk to the jury and connect with them. But every time I had to go change a slide, I'm walking all the way around our table to the thing, clicking the button, and then walking all the way back so that I could be in front of the jury and talk to them. I felt like that was a little bit of a barrier to getting to interact with them as much as I wanted to. Still feel like it was well done. I mean, there are always things you can improve. I would love it if we could record it, though, so you could watch yourself back and go,
right,
I thought that was really good, but I don't know.
Yeah.
And nobody in that courtroom is going to, you've got a bunch of lawyers who are all plaintiffs' lawyers as well. You can ask them a million times, how was it? And they're all going to say, oh, you did great.
Yeah, they're all, I mean, plaintiffs' lawyers, we just get excited when we get to go try a case, So, and it's funny because it's clear, when you're in the courtroom, it's the only people that really want to be there are the plaintiff's attorneys.
Oh, yeah, we're excited.
And then, nobody else really wants to be there. I mean, obviously the judge, it's his courtroom or her courtroom, and this is what they do, but the jury sure as hell doesn't want to be there.
No. God, no.
No, I mean, you get all kinds of excuses, to try to get out. I mean, we had a few for-cause strikes. We had 5 maybe.
Yeah.
5 or 6, I can't remember. But all right, so you did your opening statement. Then the next part is for us to put on our evidence. How did that go? Tell me a little bit about that.
It got off pretty shaky.
Yeah.
So we called the defendant first. Because we knew that one of their arguments throughout, and they made it in opening, was going to be there was minimal impact, or there wasn't enough damage, or the crash wasn't hard enough to cause injury. So we brought her up there, and I think we had 4 questions we were going to ask her. You were in the crash, right? What was the damage? Did you see the damage to your car?
The fluid leaking.
There was fluid leaking from your car, and it had to be towed.
Yeah.
Which she had admitted to in interrogatories and in her deposition. And then her answer to that last question was no. So then I had to go grab her deposition testimony, enter that into evidence. And then defense counsel's arguing it's not admissible when it clearly is under the trial rules. And then same thing with the interrogatory answers, just to make sure the jury had a clear picture of the fact that the car it was towed.
Yeah.
And I thought that went well. And honestly, I think we maybe gain a couple points there when she lies, when she says something different on the stand, and we're able to go, come on.
Yeah.
But that was very quickly wiped away.
Yeah.
In her cross-examination, when, and just to be clear for anybody listening, it's an admitted liability case.
Yeah.
Right.
It is admitted fault. They admitted 100% liability.
So there's no liability issue.
Nope.
It's a damages trial.
Correct.
So in my opinion, nothing about who this woman is as a person is relevant.
Correct.
It doesn't matter. She's already admitted
Shouldn't come
liability.
in.
She was only asked questions about the impact and the forces of impact.
It's also outside of the scope of your direct examination.
Right. And so she immediately gets asked, about what she does for a living. And I objected and said it's outside the scope of direct and it's irrelevant.
Mm-hmm.
And the judge overruled it. And then she got asked a second question about where she was living, which again is completely irrelevant to our client's damages. And I renewed the same objections. And her answer to that was that she was homeless.
Yeah.
And I still can't think of anything that could have been worse for her to say at that point. And that this is probably the biggest lesson I learned from the trial is I'm now sitting there in shock going, what?
Yeah.
And I'm looking at Judge Miller like, hey, I objected to this.
Yeah.
I really wish he would have sustained it, but I understand why he didn't. A little bit of background information is fine. Yeah. But then
it wasn't about the background information though.
Right. It was a very specific answer.
Yeah. It was about the implication that she, as a homeless person, would essentially be liable for this verdict out of pocket.
Right.
When she might have been homeless, but she did have insurance.
Right. But we can't talk about that, right?
No, we cannot talk about insurance in front of the jury.
And I think that's something people who don't do what we do don't understand. I've even talked to other lawyers who just aren't in the injury realm.
Yeah.
That have no idea that's a thing.
Yeah.
So we're not allowed to talk about insurance, but now this woman has said she's homeless.
Right.
Which is immediately...
And raising her 2 kids.
Yeah.
Homeless.
Which is immediately going to make the jury think that she can't pay a verdict.
Right.
So how can they award a verdict if she can't pay it?
Right.
And I am at that point kind of sitting there in disbelief. And then the jury, I think that was the last question.
Yeah, we took a break.
And then we took a break. And Katie Karras was sitting in, another attorney at our office was sitting in the gallery and immediately was like, hey, you guys need to do an offer of proof.
Yeah.
And try to get the limits in. So then we went through that process, doing an offer of proof, and you handled that.
It was very clunky. I haven't done one of those in a long time.
Well, it was also, we also had a defense attorney when the jury's not in the room anymore, right? And our defense attorney, and Chris hasn't tried a case in a little bit, and he's my age. So like we're the newbies, which is why I didn't jump up and object and ask for the show of proof right when it happened. And ask for a mistrial, which maybe we should have. I don't know that it would have changed anything, but now the jury's not in the room and he's still objecting as to relevance and some different things when you're doing your show of proof. And ultimately, I think Judge Miller was in agreement, certainly that it was incredibly prejudicial. It never should have been said. Yeah. But we were arguing at that point that we should be able to introduce to the jury that the insurance exists, at least that it exists and maybe even the limits. And he wasn't going to agree with us on that. Yeah,
it's. I see it from Judge's position because he kind of had a fork. He was in the fork in the road. He's like, do I admonish them? The admonishments, according to case law, the admonishments work. I think you can make an argument one way or the other. But anyways, we have to follow the law. So he could either admonish them or put in this evidence of the insurance policy limits, which is like, under almost all other circumstances would be an appealable error. Yeah. So he was in a tough spot. But frankly, I'm not sure if that necessarily had an impact on the end result. It was just something that we don't normally deal with. So if you're ever out there, you're trying a case, especially a PI case, and any kind of evidence like that comes in about the defendant's financial status or ability to pay or how much money they make. I mean, even if they try to beat around that bush and hint towards it, or I lost my job and I'm struggling now to feed my kids, shit like that. Like, no, then the insurance should come in because, that kind of sympathy is unacceptable and also opens the door.
Yeah,
absolutely. So we had that. Defendant was on the stand, and then we put the doctor on next, right? Or
I can't remember if it was Chase or the doctor.
Okay,
it may have been Chase and then the doctor.
And
either way,
we played the video. Right.
Yeah, so we put Chase on the stand. He did great. He talked about his treatment. We talked about some of the things that we knew were going to be brought up, like the fact that he had this gap, or what defense counsel was calling a gap, and that we presented an opening as him taking care of his family. It turned out he treated for like 3 months and then didn't treat for around 5. And he stopped. He went to 2 PT visits after he was referred, and then didn't go back for like 4 to 5 months.
Yeah.
And defense counsel made a big deal of that in opening, as I think they should have, right? But there was a really clear answer to that, and it was that his girlfriend, who was pregnant with his first son, her mother passed away right after his second PT visit.
Yep.
So he was trying to be there for her and her family and everyone else, and then their son was born.
Yep.
Like 3 weeks after, and I think the jury was fine with all of that. And when we talked to them afterwards, they didn't really seem to be considering that a gap, because anybody who's had a kid or anybody who's had a loved one, if their parent dies, you're going to be there for your loved one. And when you have your first kid, good luck doing anything, right, for the first 3 or 4 months, other than trying to sleep and changing diapers.
Yes.
We've both been through that. You more than me, but it's an exhausting time. So the jury was fine with that. And then we talked to him about the other issue that got brought up was the fact that he hadn't treated.
Yeah.
So he treated. Accident was in May, and he treated through December of that year. And then he had gotten an injection. His doctors told him, there's not a whole lot more we can do for you. It's not a surgery issue because it's soft tissue. The injections are going to keep wearing off. PT will work until you stop.
Yeah.
But they had found certain exercises that he could do to help relieve or release the tension and clear up that pain, and gave him a home exercise plan and said, as long as this is working for you, as long as you can manage the pain with this, you don't need to come back. And I think he did a really good job of testifying on that. Unfortunately, as we found out later, the jury, and I don't know if it had more to do with that, him not treating anymore, or the fact that he looked like Thor. We'll never know the answer to that.
Right.
But the jury looked at it like, well, if the pain was really that bad, he would have gone back to the doctor.
Or the work thing. Remember, they
the
said
fact that he didn't miss any work.
He didn't miss any work.
But again, you and I grew up in very different households from, I think, most lawyers.
Mm-hmm.
In households where you had to go to work.
Well, yeah.
You didn't have a choice.
Bills don't pay themselves.
Right. You didn't have a choice to go, oh, my back hurts, I'm just not going to go to work for a month.
Yeah.
You figured it out. And that's what he was doing. He had a new baby boy.
Yeah.
He had a girlfriend he was trying to support. So he worked through it. And he continues to work through it now. He still has issues with his back.
Yeah.
Juries get hung up on weird things, though.
Right. And again, this was Chase's only case, Chase, our client. Mm-hmm. But you and I see these things all the time. We've seen hundreds of them. Yeah. And this type of soft tissue injury where you have a spinal problem, whether it be cervical, lumbar, or thoracic spine, whatever part of your spine, and you're having these ongoing issues and ongoing symptoms, from it. But you can't really see anything on an X-ray or CT scan. So is it really there? We see it all the time.
Right. And I will say we put on, I believe it was Chase and then Dr. Gould, because I wanted him to explain it first. And then Dr. Gould to come in.
Back him up a little bit.
And back him up and give some thoughts on, well, if Chase says he's still in pain, is that reasonable? And her answers to all of that we already knew were yes. And that it was reasonable that his pain might be permanent and all those things. So we knew she was coming. She also did a good job talking about these injuries and the fact that they don't show up on x-rays. Because she got asked that question. well, there are no broken, the x-ray doesn't show any issues. And she said, well, that doesn't mean there aren't any issues. It means there aren't any broken bones, which we weren't claiming there were broken bones. And she went through a lot of that and did a really good job of talking about the mechanism of injury and I know you hate this word, whiplash.
I do.
But I don't know. I'm not sure if you hate that word or soft tissue injury more.
I hate all those stupid words.
Yeah.
I do.
But she did a really good job of explaining what that is. And it's essentially micro tears that you can't see in an x-ray and you can't see in an MRI, but it's there and it hurts.
I like micro tears more. The reason I don't like those words is because they minimize the injury, and they've been pumped up and promoted essentially through propaganda by the insurance companies, to try to make it seem like it's just not that bad. No, screw you. It is that bad. Yeah. It's absolutely that bad. They want to minimize it because, as you know, it costs a lot of money to pay for a permanent injury, and they just don't want to have to, fork over true value for a permanent injury. So, we got a lot of the common defenses, and it was a great case for them to be able to throw the kitchen sink at us. And they did. And we knew it was coming. Aside from the homeless thing, we didn't really have many surprises.
No, and I think for having that many issues in a case, we did a really good job of having it prepared in opening.
Yeah.
Defense counsel's opening statement was like 5 to 7 minutes.
Yeah.
I don't think he intended for it to be. But by the time my opening was done, the jury had heard everything he was going to say.
Yeah. Right.
What's he going to do? Say exactly what I said he's about to come up here and say?
Yeah.
So instead he fell back on use common sense opening.
Right. Common sense.
I hate that opening. So it's effective, and that's the reason I hate it.
The common sense thing. Yeah. So one of the things I would comment about as far as things that I learned after that case is if you've got a client that continues to have issues, we can't control the court's calendar.
Right.
So we're going to get trial dates years in advance. But if you have the ability to tell your client to even just follow up, even a telehealth appointment with their primary care, just saying, hey, doc, my back hurts. I do my home exercises and stretches, but just wanted to update you, and maybe the doctor will have some new treatment that they've seen or something that could potentially help. But, a lot of people are reluctant to do that because they don't want to, get pumped full of drugs or something. I mean, today is a perfect example. Today I was at CVS picking up a medication for myself, and I just had a car crash a few weeks ago. And so they had automatically refilled my prescription for cyclobenzaprine, a muscle relaxer.
Yeah.
And I hadn't even taken all the other ones, because I'm feeling a lot better, and I'm not going to pump myself full of, drugs. And so, a lot of people have that fear that they're just going to get, we'll mask it with another injection or, So, and I get it, it's kind of a pain in the ass to have to deal with it, not to mention the side effects that are associated with some of these medications.
Yeah, I mean, none of them are great.
No.
If something's going to take your pain away, it's probably going to cause something else.
Correct. Exactly. We had a $6,000 offer. What was the end result?
We ended up with a verdict of $17,500.
Okay.
I think we asked the jury for $125 because let's face it, if we're going to put that many hours into going and prepping a case for trial, we're going to shoot for the moon.
Correct.
And I don't know necessarily that we shot for the moon, but we asked for like $129. We got a verdict of $17,500. It was 3 times the offer.
Correct.
Which is a good result for our client. It's not what we wanted.
Right.
And that's maybe that's lawyer ego.
I think a lot of that is because if
I go and I remember talking to you, I was mad, right?
Yeah.
After this verdict. Because I went in and prepped this thing so hard.
Yeah.
And then to get a verdict that's $17,500 when you ask for $130.
Right.
Was like, what is that? But in reality, we still got the client 3 times what was being offered.
Right.
It was still worth it. In retrospect, it was definitely worth it to go try the case.
Exactly.
We got to show for Chicago. We'll go try this case, even though the injuries aren't huge.
Mm-hmm.
We got the client 3 times the money.
Yeah.
We had a client who was excited afterwards and texted me within an hour and said, "Thank you guys so much. I really appreciate everything you did." And that's kind of what snapped me out of being mad.
Yeah,
right?
yeah.
And I was like, "Oh, okay."
Yeah.
We didn't get what we wanted, but he's really happy with the fact that we were willing to take it there.
Yeah.
For him.
Exactly.
And he knows how hard we tried. But yeah, I think it was a good result, and learned some interesting things from the jury afterwards, which were kind of all over the place as juries normally are.
Right.
Right. You never know how it's going to go.
Yeah, that room. And that's the secret sauce right there. If you can figure out what's going on back in that room while they're deliberating. So I just, my experience generally is you've got 6 people. Half of them go one way, half of them go the other way. And I don't mean exactly half. Maybe it's 4-2 or 3-3.
A lot of the time it is, though. It's just split.
Yeah, but and then they try to compromise, and usually it's the person with the strongest personality in that room that's going to come out on top. Yeah, those are your people.
It's the loudest person in the room. And I remember during closing specifically, one of the things we used was talking. We didn't want to tell the jury to give him a certain amount,
right?
Or say this is what we're asking for. We used a formula, and I think David Ball does this. It's where I got it from. Was to say, okay, here is meds. These are the harms that you can make up for by including those in the verdict. You can include that $7,500, but then there are things that you can't make up for, like his pain.
Mm-hmm.
And then giving them a way to calculate that pain and essentially saying, okay, our doctor said it's permanent, or it could be. That probably should have been objected to, but I'll take it.
I know.
I'll take it coming in.
Could have moved for a directed verdict on that.
Yeah, for sure. And I was worried they might at trial. And then we said, okay, so even if you think his pain is minimum, let's use minimum wage for minimum pain. And we talked to the jury about that later. They thought it was interesting, or I don't know how many of them sided with it. Obviously not enough. But take that number, multiply it by 365 days a year times the 40 years Chase has left to live. And that's how we came up. Add that to the 7,500. That's how you get to that 129. So there were very interesting things that we did during the trial, and things that I learned, and things the jury liked. And then we kind of gave the jury the option with that minimum wage $7.25 of, if you think his pain's worse than that, go up. But here's the formula. Or if you think it's less than that, go down.
Yeah.
And we talked to the jury afterwards, and they really appreciated that we didn't say, give him this.
We justified it.
We justified it and said,
the
it's
per diem
your
argument.
job to come up with it. It's not our job. It's your job. But
this is our suggestion.
Yeah. Here's how you can do
$1 million.
Yeah. I'm just going to start saying that every time. But yeah, we learned a lot, I think. And it was really helpful that we got to talk to the jury after the
trial. All 6 of them. 7.
That doesn't always happen.
Yeah, including
and the things
including the alternate cop, right?
Yeah. Yeah. It was interesting how many of them, I remember being struck by how many of them were stuck on the fact that he doesn't look like he's hurt.
Yeah.
Because he doesn't. He's my age. He's 33. He's like 6'5". Looks like he works out every day. He's got long hair and a big beard.
Yeah.
I'm not kidding. None of you guys are ever going to see Chase, but he looks like Thor.
Yeah.
And his nickname, like people call him Thor. He's huge. And they were stuck on the fact that he was, he didn't look like he was hurt. I think that was most of it, really. Yeah. And the fact that he didn't miss work was another big one that I don't even know I thought about as an issue that would come up.
Yeah. I think we put his brother on because he works with his brother. Mm-hmm. We probably could have had someone that wasn't a relative as the quote unquote grunt and groan witness, but he did a good job, and obviously we have limitations based on the case, the witness lists and things like that we have to kind of abide by. So,
and that was another issue the jury brought up, was that they didn't really consider the brother's testimony because he was biased.
Yeah,
that's another lesson.
Yeah,
but we've had juries do the opposite.
Yeah.
Who, the case Katie and I tried a couple years ago,
Mm-hmm.
the only grunt and groan witness was his wife.
Right. I remember that. Yeah.
And she got, I think I asked her like 6 questions.
Yeah.
And the jury came back with a verdict that was much
Wow.
closer to what
Yeah.
we were asking for,
Right.
right?
Exactly.
But yeah.
So, based on this experience, what advice would you give to a young trial lawyer getting ready to go try a case?
Know your rules of evidence.
Yeah.
Inside and out, know the case law, because that was the biggest thing that I took away from this case was when the issue of her being homeless came up.
Yeah.
We want to try as many cases as we can.
Yeah.
But realistically, in what we do, we don't get to try that many. So there's always going to be an issue that comes up in every case that you've never dealt with before.
Correct.
And you have to be prepared for it.
Right.
Even though we could have never expected that was going to come up.
Yeah.
And it's never come up before. But if you're going to try cases, know the case law surrounding it. Know the rules of evidence, because those benefited us several times.
Oh, yeah. In the past, too, when we've tried cases.
Yeah, where there were evidentiary objections and different things. And honestly, we used her deposition in this case.
Yeah.
And I learned that you could do that in the last case I tried when the defense attorney brought it up in his closing.
Right.
He brought up our client's deposition when our client had already been on the stand.
Exactly.
He'd already crossed him. So,
right.
And it's a fairly new trial rule. I think it was only introduced 3 or 4 years ago.
Yeah.
Prepare.
Be ready.
Prepare.
Over prepare.
Yeah, which I don't have an issue with that. That's kind of the norm. But yeah, definitely knowing the rules of evidence and the case law. And honestly, be ready to go try the case and don't get discouraged by a verdict that you're not happy with. The client was I was upset because I wanted to do better for the client.
Yeah.
And the client was thrilled.
Right.
And if the client's thrilled, that means he or she thinks you did a pretty good job.
Oh, yeah. Oh, man, we came in swinging.
Yeah.
You know, that second close that I had, I put Chris's picture up there and like up on the, I mean, I told his partners, the guys that, he works for, I said, we did not hold back because, I mean, that's our mindset. You're going to force us to go try a case, even if you consider it a little soft tissue case, we're coming in swinging. Well,
and we saw Chris like the next night.
Yeah.
There was an indie bar function. And it's interesting how, we've talked about this before, how adversarial I think lawyers in a lot of other places are and how they aren't here.
Mm-hmm.
Like the first person I saw when I walked in was Chris, who I just tried a case against 2 days ago.
Yeah.
And we sat and had like a 20-minute conversation. He talked to me about the fact that he wanted to object to us putting his photo up there in your second close, but he was like, but I couldn't.
What's the basis?
I don't know what the objection would have been.
Too argumentative.
And I don't know either. But
well, I was kind of being a dick, but I mean, I guess you could say that. Alex is being an asshole, Judge.
Objection. I don't like this. He's being mean.
Yeah.
No, and then the other lesson I think I learned, not just inside this case or what I'd tell the other lawyers, is that even if you don't get the result for the client who you're trying the case on behalf of, it comes back when defense counsel and the insurance companies know you're willing to go try the case.
Yeah.
In this case, we didn't get the verdict we wanted, but we did beat the offer by 3 times. But then a week later, another attorney from the same law firm that we just tried the case against called and offered me 3 times what had been previously offered on another case, and we were able to get it resolved.
Yes.
I have a hard time believing that that's not because they went, these guys know what they're doing.
Right.
And they're willing to go do it.
Yeah.
So
exactly.
I think that's always the biggest lesson.
Yeah.
If you just have to be willing to put in the work and willing to go try the case.
Right.
Otherwise, what are you doing being a trial lawyer?
Well, don't call yourself a trial lawyer. You know?
I used to struggle with it because I did.
You hadn't tried a case?
It's so hard to try a case when you're young.
I know. Yeah.
And we called ourselves trial lawyers. I'm like, I haven't tried a case.
Yeah.
I didn't try a case for the first 5 years I was practicing.
Yeah.
But I'm calling myself a trial lawyer. And in ways you are. if you're prepping for trial, you're getting it at the doorsteps.
Litigation.
And then you're settling it.
Yeah.
Trying a case is very different, though. I remember the first one I tried and how nervous I was. Even though I was doing very little, I was trying that case with Katie, who was gracious enough to allow me to, kind of took me in and said, hey, you're going to come watch me do this so you can learn how to do it, and gave me a little bit to do. And I was so nervous. And now I don't.
Yeah.
Other than apparently speaking in a country accent for the first 2 minutes of my opening, I don't think I was nervous at all.
Well, you're from Switzerland County, so.
Yeah, it comes out when I'm nervous.
Yeah.
It's weird.
That's on the border there, so.
Yeah.
When the closest big city is Bedford, Kentucky.
Yeah.
So
there's not much there.
Which we used to go across there because that's where, Kentucky taxes on alcohol and tobacco are much lower than Indiana. So, well, and a couple of things that you had just mentioned. First of all, when we go try a case for a client, our office doesn't increase the fee, which is one thing that a lot of other lawyers will do.
I bring that up when we're talking to potential new clients all the time, as we enjoy trying cases.
Yeah.
I'm not going to charge someone more if they're going to let me go try their case.
Yeah. Yeah. Fee stays the same. And then another thing you mentioned, which we had Lee Christie on the show before, and Lee has mediated cases. He's gotten massive verdicts in Indiana against Tesla, and worked with the likes of Nick Rowley and some really great trial lawyers. And Lee said to me, he said, Alex, there's settlement trial lawyers, and then there's, real trial lawyers.
Yeah.
And so there's a big difference, between the two. And it's kind of like you said, frankly, part of the reason why I went and tried the case with you is because I was feeling a little imposter syndrome myself,
right?
Calling myself a trial lawyer and not having tried a case for a while.
Yeah.
And so I said, screw that. I'm going to go try this case with Chase, and so even if it is, a smaller, quote unquote, smaller case, to us, it doesn't really matter because it's all about the client as long as they're happy. So anyone out there listening, lawyers, litigators, if you're facing a tough legal challenge, if you've got a trial coming up, you want to work with someone, we co-counsel cases all the time with folks. We love co-counseling, working with other lawyers. 2 lawyer minds are better than one. Usually only when it comes to cases. In other circumstances, more than one lawyer may not be that good of a thing. So, but yeah, if you want an experienced trial lawyer to work with you on your case, we would be glad to help you out. Thank you for joining us today. Thank you to Chase. Thank you, Chase, for being here.
Thank you for having me.
Thank you for joining us today on Circle City Conversations. Don't forget to subscribe and stay tuned for more thought-provoking conversations like this one with Chase Wilson.